In this lecture, we're going to be covering chapters 22, 23, and 24 in our business law text. Chapter 22, promissory notes and drafts. If you're following along in your e-text, I'm starting on page 22-1, notes. Any written promise to pay money. The maker of a promissory note has accountability for expressly agreeing to pay the note according to its terms, admitting the existence of the note and of the payee, warranting the payee is competent to transfer the instrument by endorsement. Different types of notes. A bond is a sealed written contract of obligation with essentials of a note issued by a corporation, municipality, or a government. For example, the Panama Canal was first funded by the French government bonds. A collateral note is a note secured by intangible personal property, such as stocks or bonds. A real estate mortgage note is a note secured by real property. Debentures are unsecured bonds issued by a business. An example would be an initial public offering by a company going public. Certificates of deposit. This is an acknowledgement by the bank of receipt of money with the promise to pay back that money with interest. Drafts. This is a paper ordering a bank to pay the payee. Forms of drafts. There's a sight draft, which is payable on presentation by the holder, and time drafts, which are payable specified in a number of days or months after the date of presentation. Trade of acceptance orders the purchaser to pay the seller. These are used in the sale of goods. The draft drawn by the seller on the purchaser of goods. The seller is the drawee and the purchaser is the drawee. The seller is the drawer. Presentment for acceptance. Acceptance destroys the negotiability of an instrument. Therefore, the transaction is complete. All trade acceptances and all time drafts must be presented for acceptance by the payee to the drawee. Acceptance is the agreement to pay the instrument. Presentation for acceptance. Place is the instrument should be presented at the drawee's place of business, or if there is no place of business, at the drawee's residence. Party. Draft must be presented to the drawee or someone authorized by law or by contract to do so. Form of acceptance. The usual form of acceptance is the word accepted followed by the drawee's signature. The signature alone is sufficient to constitute a valid acceptance. Accepted written on the draft shows an intent to accept. Admissions of the acceptor. The signature of the drawee is genuine. The drawer has both the capacity and the authority to draw the draft. With money orders, an instrument issued by a bank, post office, grocery store, etc., indicating the payee may receive the indicated amount. It's a contract to pay. Checks. Checks are a type of draft which is payable on demand and drawn on a bank. Special kinds of checks. Certified checks. This is a check accepted by a bank. The bank is liable for payment. Cashier's check is a check drawn on its own funds. Bank drafts, the check drawn by one bank on another bank. You could think of this as the bank's personal checking account. Voucher checks, this is a check that lists the items for which the check is the means of payment. Therefore, it also acts as a type of receipt. Traveler's checks, cashier's check with the added requirement of a signature when purchased and a counter signature when negotiated. Post-dated checks, this is a check drawn before its date. An example would be drawn on the 21st, but dated July 1st. And this essentially turns the check into a draft. Bad checks, a check drawn with the intent to defraud the payee. An example would be a check drawn on a closed account or on an account with insufficient funds. Duties of the bank: maintain secrecy regarding depositor-bank relationship. Duty of comparing the signature on the depositor's checks with the signature of the depositor in the bank's files. Refusal to pay of the bank to pay. The bank has a duty to pay on demand for all checks. If this contract is breached, the bank is liable to the drawer for damages. Stale checks. This is a check that has not been negotiated or deposited after 6 months. Stopping payment. Drawers have the power to stop payment of checks. Stop payment may be written or oral. The bank is bound by 14 calendar days if it is an oral request for stop payment. Payment after depositor's death. Generally, a check is ineffective after the drawer dies. Until the bank is notified of the drawer's death, the bank's agency is not revoked. Bank customers' responsibility. Customers must examine monthly bank statements and notify the bank with reasonable promptness of any forged signatures. If the bank suffers a loss because a customer fails to do this, the customer may be liable. Let's do our chapter review questions for chapter 22. Who are the original parties to a promissory note? The original parties to a promissory note are the maker, the one who signs the note and promises to pay, and the payee, the one to whom the promise is made. Question 2. For what can the maker of a note be held accountable? The maker of a note can be held accountable for agreeing to pay the note according to its terms, admitting the existence of the payee, and warranting that the payee is competent to transfer the instrument by endorsement. Question 3. What are the differences among a bond, a collateral note, a real estate mortgage note, a debenture, and a certificate of deposit. A bond is a written contract obligation that contains a promise to pay a sum certain in money at a fixed or determinable future time. A collateral note is a note secured by personal property. A real estate mortgage note is a note secured by a mortgage on real estate or real property. A debenture is an unsecured bond or note issued by a business. Question 4. What does the drawee of a draft do? The drawee of a draft pays the amount to the payee or some other party to whom the payee has transferred the instrument by endorsement. Question 5. Why must a time draft payable a specified number of days after sight be presented for acceptance? A time draft payable a specified number of days after sight must be presented for acceptance because the due date is calculated from the date of the acceptance, not from the date of the draft. Question 6. What is a trade acceptance? A trade acceptance is a draft drawn by the seller on the purchaser of goods sold and accepted by such purchaser. Question 7. Is presentment for acceptance of drafts that are not payable a specified time after sight necessary? Presentment for acceptance of drafts that are not payable a specified time after sight is optional and is made merely to determine the intention of the drawee and to give the paper the additional credit strength of acceptance. Question 8. In what way does a drawee accept the draft? The drawee can accept a draft by signature alone. However, adding the word accepted is advisable to make clear that acceptance is intended. Question 9. When the drawee accepts a draft, what admissions are made concerning the drawer? When the drawee accepts the draft, the following admissions are made concerning the drawer: that the signature of the drawer is genuine, and that the drawer has both the capacity and the authority to draw the draft. Question 10. What is the effect of the certification of a check? The certification of a check by the bank makes the bank liable for the payment of the check and bonds it by the warranties made by an acceptor. Question 11. How does a traveler's check differ from a cashier's check? A traveler's check differs from a cashier's check in that it requires signature and countersignature by its purchaser. Question 12. What is the duty and potential liability of a bank that refuses to pay a depositor's check? A bank has a contractual duty to its depositors to pay on demand all of their checks to the extent of the funds deposited to their credit. When the bank breaches this contract, it is liable to the drawer for damages. Chapter 23, Negotiation and Discharge. Place of endorsement. An endorsement is the signature on the back of a negotiable instrument with any directions or limitations. Banks require the endorsement be within 1.5 inches of the trailing edge on the check on the back. A trailing edge is the left side of the front of the check. If the endorser's signature appears elsewhere and it cannot be determined what the signature is for, it will be considered an endorsement. In the case of a clerical error and the endorsee's name is misspelled, the endorsee may ask her employer for a new check to be made out to her. An irregularity such as this does not destroy the negotiability of the check. Multiple payees. Negotiable instruments can be made payable to more than one party based on the language used. If "and" is used between their names, the parties must endorse the check jointly. If "or" is used in between their names, either party can endorse the check. If it is unclear whether the check can be payable jointly or alternatively, it will be payable alternatively. Kinds of endorsements. Blank endorsements. Only the name of the endorser is on the check. It makes it bare paper. Special endorsements designates to whom payment should be made. This would be order paper. Qualified endorsements limits liability of the person collecting the instrument for another, such as without recourse would be a qualified endorsement. Restrictive endorsements limits the instrument to a specific use, such as writing under your name, deposit only. Liabilities for payment of the instrument. The endorser has an obligation to pay the face amount of the instrument if the holder presents it to the primary party and the primary party refuses to pay. Discharge of the obligation. Payment by the liable party will discharge the obligation. Cancellation. Any act that indicates the intention to destroy the instrument. Renunciation. The holder gives up his rights to the instrument. And then discharge by an operation of law such as bankruptcy or the statute of limitations. Let's do our chapter review questions for chapter 23. What is an endorsement? An endorsement is a signature on the back of an instrument, usually the holder's, along with any directions or limitations regarding use of or liability for the instrument. Question 2. Why might a transferee require an endorsement on bare paper? A transferee might require an endorsement on bare paper because it adds the liability of the new endorser to the paper and thus makes it a better credit risk. Question 3. If an instrument is to be endorsed, where must the endorsement be found? If an instrument is to be endorsed, the endorsement must be on the actual instrument to be endorsed or on paper attached to the instrument. Question 4. Does an irregularity in the name of a party to an instrument destroy its negotiability? An irregularity in the name of a party to an instrument does not necessarily destroy negotiability. Only if it is shown that different people were actually identified by the different names is the irregularity significant. Question 5. When there are multiple payees on an instrument, how can one know whether all must endorse or only one need endorse the instrument to negotiate it? When there are multiple payees, by making an endorsement, all endorsers except qualified endorsers agree to pay any subsequent holder the face amount of the instrument. If the holder presents the instrument to the primary party when due, and the primary party refuses to pay. Question 6. Name 4 kinds of endorsements. Give examples. 6A. A blank endorsement consists of the name only, such as John Jones has a check payable to himself. He is in a store and wishes to use the check to pay for what he has purchased. He is safe in endorsing the check in blank. B. A special endorsement designates the particular person to whom payment is to be made. Paid to the order of Mary Smith, for example. A. Roe. Roe wished to mail this check to Smith in payment of a debt she owed Smith. To prevent someone else from cashing this check without endorsement, Roe could use this special endorsement. Paid to the order of Mary Smith, signed by A. Roe. A qualified endorsement has the effect of qualifying or limiting the ability of the endorser, such as without recourse, signed A. Roe. Here, Roe wishes to transfer title but does not wish to guarantee that the drawer will pay it upon presentment due to the possibility of insufficient funds or refusal to pay. 6D. A restrictive endorsement is one that attempts to prevent the use of the instrument for anything except the stated use. It may be used if the endorsee holds the paper for a special purpose or as an agent or trustee for another. Paid to the order of Hancock National Bank for deposit, signed A. Roe. In this case, Roe merely wants to transfer possession to the bank as an agent to collect. Question 7. By making an endorsement, what do all endorsers except qualified endorsers agree to? By making an endorsement, all endorsers except qualified endorsers agree to pay any subsequent holder the face amount of the instrument if the holder presents the instrument to the primary party when due and the primary party refuses to pay. Question 8. How does an endorsement without recourse affect the endorser's warranty liability? An endorsement without recourse does not affect warranties, so that the warranty liability of a qualified endorser is the same as that of an unqualified endorser. Question 9. What does a person who negotiates a bearer instrument by delivery alone warrant? A person who negotiates a bearer instrument by delivery alone warrants the genuineness of the instrument, title to it, the capacity of prior parties, and its validity. Question 10. How may a negotiable instrument be discharged? A negotiable instrument may be discharged by payment, cancellation, or renunciation. Chapter 24. Liabilities of parties and holders in due course. The Uniform Commercial Code imposes liability on parties to negotiable instruments. Contractual liability is the liability created by what is written on the face of the commercial paper. Warranty is the liability for breach of warranties regarding the instrument. liability for the face of the paper, primary liability, liability without conditions for commercial paper that is due. Maker is the person who promised to pay, and the drawer accepted the draft and is therefore ordered to pay. Secondary liability, liability for a negotiable instrument that has been presented and dishonored, and for which notice of dishonor has been given. Liability for the face of the paper. Secondary liability continued. Conditions for being secondarily liable. Presentment. The instrument must be properly presented for payment. Dishonor. Payment on the negotiable instrument is refused. Notice of the dishonor must be given to the party who is to be held secondarily liable. The Uniform Commercial Code says notice must be given by the next business day. Guarantors. Endorsers can escalate their liability to primary status by endorsing an instrument, by putting in payment guaranteed, or indicating the endorser agrees to pay the instrument if it is not paid when due. Guarantors. If the transferor endorses the instrument with the words collection guaranteed, secondary liability is preserved. People act as guarantors to increase the security of commercial paper. Unauthorized signatures. Generally, an unauthorized signature does not bond the person whose name is used, especially if the signature is a forgery. Two exceptions. One is when the person whose name is signed ratifies the signature. Another is when the negligence of the person whose name is signed contributed to the forgery. Liability for warranties. Liability of agents. If an authorized agent signs a negotiable instrument, the principal will be liable. So if John Smith, the principal, by Jane Doe agent, in that situation, an authorized agent, Jane Doe, signed the negotiable instrument on behalf of the principal, John Smith, and therefore the principal will be liable for the negotiable instrument. If the agent has not indicated a representative capacity and has not identified the person represented, the agent will be liable. Holders in due course. A holder in due course is an innocent purchaser that has immunity against simple contract offenses. Holder in due course requirements. The holder must take the instrument in good faith and for value. The holder must have no notice the instrument is overdue or has been dishonored. At the time the instrument is negotiated, the holder must have had no notice of any defense against or claim to the instrument. So holders in due course for value and in good faith. To attain the status of being a holder in due course, the holder must give value for the paper. A promise does not constitute value. Good faith means honesty in fact and the observance of reasonable commercial standards of fair dealing. No knowledge that the instrument is past due or dishonored. One who takes an instrument known to be past due cannot be an innocent purchaser and therefore cannot be a holder in due course. no knowledge of any defense or claim to the instrument. When one takes a negotiable instrument to obtain the rights of an innocent purchaser, there must be no knowledge of any defense against or claim adverse to that instrument. Knowledge of any other potential irregularities, however, does not destroy holder in due course status. Holder subsequent to a holder in due course, also known as holder through a holder in due course. In this situation, we apply the shelter principle, a rule giving a holder. So this is someone who takes possession of the instrument after a holder in due course has the rights of the original holder in due course. Holders of consumer paper, negotiable instruments given for consumer goods or services, which are goods and services for personal, family, or household use. Generally, the rights of the holder of consumer paper are subject to all the claims, defenses, and set-offs of the original purchaser and debtor arising from the consumer transaction. In other words, consumer goods and services are not going to give rise to a holder in due course. Consumer goods or services are goods or services primarily for personal, family, or household use. A claim by the party being sued against a party suing, this is known as a set-off. Let's look at our chapter review questions for chapter 24. Question 1. Upon what does imposition of liability on parties to negotiable instruments under the UCC depend? Imposition of liability on parties to negotiable instruments under the Uniform Commercial Code depends on the nature of the paper, the role of the party as maker, acceptor, endorser, or transferor, and the satisfaction of certain requirements of conduct by the holder of the instrument. What can constitute a signature on a negotiable instrument? A signature can be any name, including a trade or assumed name, and may be handwritten, typed, or printed. It can even be a word or logo in place of an actual signature. Question 3. How does the drawee of a draft become liable on an instrument, and what kind of liability does such a drawee have? The drawee of a draft becomes liable on an instrument by accepting the draft by writing accepted and signing it. The acceptance renders the drawee primarily liable. Question 4. What conditions must be met for a party to be held secondarily liable? For a party to be held secondarily liable, the instrument must be properly presented for payment, the instrument must be dishonored, and notice of the dishonor must be given to the party who is to be held secondarily liable. Question 5. What is required for a proper presentment? For a proper presentment, the instrument should be presented to the correct person in a proper and timely manner. Question 6. When does dishonor of a negotiable instrument occur? Dishonor of a negotiable instrument occurs when a presentment is made and a due acceptance or payment is refused or cannot be obtained within the prescribed time. Question 7. According to the UCC, when must notice of dishonor be given? According to the Uniform Commercial Code, notice of dishonor must be given by a bank by midnight of the next banking day following the day on which it receives notice of dishonor. All other holders must give notice within 30 days following the day on which notice of dishonor is received. Question 8. How can endorsers escalate their liability to primary status? Endorsers can escalate their liability to primary status by endorsing an instrument, payment guaranteed. Question 9. What are the 2 exceptions to the rule that an unauthorized signature does not bind the person whose name is used? The 2 exceptions to the rule that an unauthorized signature does not bind the person whose name is used include when someone signs an instrument on behalf of the maker or drawer, but intends the payee to have no interest in the instrument. The other is when an employer entrusts an employee with responsibility with respect to an instrument and the employee makes a fraudulent endorsement in the name of the payee. Question 10. What are the 3 required conditions for a holder to be a holder in due course? For a holder to be a holder in due course, the holder must take the instrument in good faith and for value, have no notice the instrument is overdue or has been dishonored, and have had no notice at the time the instrument is negotiated of any defense against or claim to the instrument. Question 11. Can a purchaser of demand paper on which demand for payment has been made and refused be a holder in due course? For a holder to be a holder in due course, the holder must take the instrument in good faith and for value, have no notice the instrument is overdue or has been dishonored, and have no notice at the time the instrument is negotiated of any defense against or claim to the instrument. Question 11. Can a purchaser of demand paper on which demand for payment has been made and refused be a holder in due course? A purchaser of demand paper on which demand for payment has been made and refused can be a holder in due course if the purchaser has no notice of the demand. Question 12. What is the shelter rule? The shelter rule allows a person who would otherwise not be a holder in due course to have the rights of such a holder if a holder in due course was the previous holder.